the joint meeting of the Senate and House Judiciary Committees. We have a busy schedule today, but want to welcome all of you here today.
And I just ditto those comments. Welcome. Thank you for being flexible committees and meeting in different rooms and different times. The House is, we're going to start just to make sure that we don't have any requests for bill introductions. If you do, please, now would be the time for that. Okay, don't see any. So I think we're ready to go on with our agenda.
Great. Well, with that, then we are going to hear an update on the judicial branch, and we will be hearing from Chief Justice Marla Lugert, who will be presenting, and we'd invite Madam Chief Justice to the podium then. Please introduce yourself, Madam, just for the sake of the record and those following along out of the committee meeting room as well. And welcome to the joint committee here today.
Thank you. Thank you, Chairwoman.
And if you want to turn on your microphone, and away we go. Thank you.
Good. Okay. Thank you, Chairwoman Warren and Chairwoman Humphreys, for this invitation. I am Chief Justice Marla Lugert. I have served in that role as Chief Justice since just a few weeks before COVID, and have so still feel like I am fairly new to the role, and looking forward to a day when it is a role that seems normal and without crisis. So. But I do appreciate the opportunity to visit with you today. My State of the Judiciary address last week was just covered just a fraction of the many innovative and exciting things that we have going on in the judicial branch. And so I appreciate being able to give you a few more details and some information, as well as to answer the questions that you have asked me to address. I will begin with just a real brief report on access to justice issues, provide an overview of general case filings and dispositions, focusing on criminal cases. And in response to the questions I was asked, I will discuss time standards, use of remote technology for hearings, the judicial branch budget request, and restoration efforts following our cybersecurity incident. You will find more detail on all of those topics and a few others in my written testimony. As for the access to justice, I wanted to tell you about an innovative eviction diversion program underway in Sedgwick County. Civil diversion operates within or adjacent to regular court processes and provides litigants with information, resources, and alternative pathways to dispute resolution. These programs resolve disputes with less expense and typically a shorter time than a traditional court process. Recognizing that parties come to these courts often without the representation of an attorney, we provide information to both the landlords and the tenants about community resources for both groups, as well as about the processes for eviction proceedings. The innovative program is helping both landlords and tenants. It's improving housing stability, and it's providing pathways to fair and timely disposition of these disputes. Evictions are only one of many types of cases where we are seeing more and more self-represented litigants. To meet the needs of those litigants, we continue to build resources that help them navigate the court system. Several courts for many years have had help centers in the courthouses or other facilities near the courthouses where public can come to get forms and information, use the computers to check court records, and otherwise prepare for court. 4 new help centers opened in 2023 and 10 are slated to open in 2024. In addition, we have a judicial fellow from Georgetown. This fellow is studying the e-filing needs of these self-represented individuals and is designing an e-filing protocol to meet those needs. These few examples hopefully give you a glimpse of some of the steps that we are taking to meet the needs of Kansans and to meet them where they are, not where we expect them to be necessarily. And these are just a fraction of the innovative programs that we have underway. I won't touch on the others because I do want to address your questions, but I do quickly want to tell you about one more effort that we're very excited about. Last summer, a committee that includes Senator Brenda Dietrich began meeting to design a learning center that will be housed on the first floor of the Kansas Judicial Center. This interactive center will provide information and educate visitors about all three branches of government, and explain how they function and how they interact. We are very excited about this project, and we look forward to welcoming you and your constituents as you visit the center soon. So turning to the topics I was asked to address, I have provided some more detailed statistical information about case filings in my written testimony. In general, like courts across the country, Kansas cases still remain at levels that are below what we typically saw before COVID. But filings in fiscal year 2023 increased, with total filings growing by about 12,300 cases over fiscal year 2022. The other trend you ask about relates to the clearing of the backup of criminal cases caused by the COVID pandemic. I think it is fair to say that does not exist. At the time the legislature of COVID suspended the statutory speedy trial deadlines, the 2023 legislature passed HB 2121 that extended statutory speedy trial deadlines until March 1st of this year. As I have talked with the chief judges across the state, almost all have responded. They do not have a backlog of criminal cases. They are back to handling what they would consider a normal, very busy, very packed criminal caseload. And almost every district feels prepared to handle the reinstatement of the speedy trial deadlines. That said, a few districts are very nervous. And their sense of anxiety arises in part because of the lack of resources for the partners that were required to help us handle those cases. Many mention concerns about the lack of personnel in county and district attorney's offices and the lack of attorneys on the defense side who would accept appointments or take appointments to handle these cases. So many report that the criminal caseload remains very heavy and scheduling trials is very difficult because of this shortage of attorneys. As I understand and as relayed to me, and especially in certain areas, these entities are not able to be competitive in salaries to attract individuals. And generally what we have are judges who are struggling to find attorneys who can take appointments because they either lack the level of experience that is required to handle high level felonies and really on down the tier of felonies, but also who are in the right places at the right time and have the ability to take on additional cases on an already heavy caseload. So even if the court decides to expand its criminal docket and be able to flow more cases through or more trials through on the court side without the ability to schedule the attorneys to represent the state and the defendants, we cannot really make headway on that. And some of that is also non-budgetary. There are always things that happen that create a wrinkle. This morning, a water pipe in the Douglas County Courthouse froze and broke and flooded a basement courtroom. Losing just one courtroom out of a busy courthouse will create a significant impact on case flow. Districts have adapted new procedures to try to deal with this caseload. Criminal mediation has expanded statewide. It was one of the things that grew rapidly during the COVID years. and special processes have been established. As one example, Sedgwick County used ARPA grant money to retain a private law firm to defend the accused of crime, those accused of crimes. This added to the pool of available defense counsel and kept cases out of an overwhelmed and overburdened public defender office. Sedgwick County set up what they referred to as a resolution docket. That docket was originally intended to be a process for handling the backlog of property crimes and other low-level crimes that the district attorney had not filed during COVID. But it turns out that it works so well that they've continued to build on that and continue to use it to resolve cases. They converted their courthouse cafeteria to a makeshift courtroom, and they implemented special procedures such as early discovery in the cases, and they encouraged and made available processes to incentivize early plea bargain discussions between the parties. These special processes streamlined procedures and allowed the handling of cases more expeditiously. In a conversation I had last week with the judge handling this docket, he told me that he just had ended the guilt phase of a trial, of a case, that was filed in mid-December. Judges have also worked very hard. One judge alone handled more than 40 first-degree murder cases. I'll tell you, that is an extraordinary effort and commitment. Turning to another topic, Chairwoman Warren asked me about what deadlines, other than the speedy trial deadlines, apply to processing cases.
Madam
The short
Chief.
answer is that I'm sorry?
Oh, I appreciate you introducing a new topic, but if I could just stop for a moment and ask committee members, are there any questions for the chief up to this point that we have? We've covered two big topics already and about to enter a third topic, but are there any questions? Seeing none, then go ahead and proceed, Madam Chief. Thank you.
Well, the short answer to the senator's question is that the Kansas Supreme Court has time standards for the processing of all cases and other time standards for judges to make decisions on anything they take under advisement. I've set out some of those details in my written testimony, as well as given the citations to where those standards and accompanying rules can be found. I was also asked to discuss the use of remote hearings, especially in evidentiary hearings. Just for those of you who may not be familiar, due to the health and safety concerns of COVID, special legislation was passed that allowed courts, and this covers from municipal courts to all levels of courts in the state court system, to use remote proceedings as authorized by the statute and Supreme Court rule. Currently, judges have the discretion to conduct a remote hearing when it is necessary to secure health and safety of court users, staff, or judicial officers, or to expeditiously resolve pending cases. In my written testimony, I have included much more, a lengthier discussion about all of the factors that might go into a judge's decision about whether to use the judge's discretion to have a remote hearing or an in-person proceeding. Broadly speaking, though, I would say that across the state, 3 years after we have begun using remote proceedings, remote hearings are today used more widely for status and other pretrial conferences, other non-evidentiary hearings, and uncontested evidentiary hearings. Even during the worst days of COVID, judges across the state were reticent and declined to follow what was happening in some of our other sister states, and we did not conduct remote jury trials. The use for other evidentiary hearings, such as motions or a court trial, varies widely and is usually based on a variety of factors. These factors might include whether the parties request a hearing, consent to it. If they don't, it usually doesn't happen. It also may be whether an interpreter is needed and the language interpreter is unavailable in the jurisdiction. It may also be that there need to be accommodations because of an out-of-state witness or because of a disability or illness of a witness or a party. Even if the parties request to have a hearing by remote means, a judge may not grant the request, especially if the judge feels that it is inappropriate. And often that is because of technical considerations about the availability of the and access to well-working technology that would facilitate the hearing. Generally, parties seem to appreciate the ability to appear remotely. Between April and June 2022, 6 judicial districts in Kansas joined other courts across the country in surveying court users about their experiences with remote hearings. So this is in a time period when we were using remote hearings for a lot more than we are today even. The National Center for State Courts summarized those findings into a few lessons. I will mention some of those lessons that might be of interest to you. First, on average, court users believed remote proceedings are at least as accessible and fair as in-person proceedings. This means that overall, those with actual experience with remote proceedings was positive, and they rated them often as more accessible and fair than in-person proceedings. Second lesson, participants who can choose between in-person and remote proceedings view the court as more accessible and fair. We always want people to view us as more accessible and fair. Court users have a better experience in court when they can choose. These court users gave significantly higher ratings in both access and fairness when given that voice. Because remote proceedings are not equally beneficial for every court user and for every court situation, this finding suggests that courts should allow users to choose or to at least have input in setting their proceedings whenever possible. The feedback I have from judges across the state is that our judges understand this, respect this, and they allow the attorneys and the litigants to make requests and to give voice to whether they consent or don't to the remote proceeding. The third lesson was that most remote users across the court, most court users access the court from home or work. 1/4 of the remote court users access court while at work, which they would not be able to do, obviously, if they were appearing in court in person. This finding suggests, as we have learned, that remote proceedings are benefiting court users because they do not need to take off time from work to appear in court. Kansas judges agree. Appearance rates for such things as child support dockets have increased where participants can appear remotely. Scheduling a short work break to attend a short hearing saves time away from work. Having to go to court and take that half day or day off work to travel and get there and have the proceeding and get back can jeopardize employment or decrease income. In general, in summary, remote hearings reduce the cost of litigation, reduce delays, and enhance court efficiency. As to that efficiency, a couple of examples. One judge in Western Kansas told me he used to spend a week a month traveling to the 6 counties in his district for short status type hearings in the child support docket. He now schedules all of that by Zoom and conducts all of that business in half a day. Obviously, that frees up 4.5 days for him to devote to more complex matters and to be able to help set other things more quickly than he could have otherwise. I would also mention that remote hearings help with the shortage of attorneys that we do face statewide. I've already mentioned this in terms of criminal cases, but it's also a reality in civil cases. Attorneys from other parts of the state are more willing to accept criminal appointments when they only need to travel once or twice to handle a case for the trial, preliminary hearing, or perhaps other evidentiary hearings, but can do all the motion and the status hearings and other things remotely. Judges report that this helps them recruit attorneys who are willing to take the cases, and it has also helped them find attorneys who can speak the accused native language, which has been a big help. It also helps our state budget, as, for example, an attorney who accepts criminal appointments recently reported he appeared in Great Bend, Larned, Norton, and Hayes all in one day without leaving his office. All were cases that he is being paid for by the Board of Indigent Defense Services. The same access benefits in civil cases as well. Attorneys can afford to take cases outside their home communities, and their clients can afford to hire them for those cases. They don't have to pay the travel expenses. And I know Kansas Legal Services is here, but I know that they haven't been able to broaden their geographic coverage and scope of cases at times when judges have allowed remote proceedings. Overall, I would tell you that the courts and the judges, the attorneys, and the litigants appreciate the ability to have discretion to use remote proceedings in their cases. The next topic I was asked to discuss was our budget. We, of course, submitted our fiscal 2025 budget in September. Beyond our base budget, we have requested a 5% cost of living increase. As I spoke about this in my State of the Judiciary, I won't go into more detail about that. We have asked, as I mentioned then, for some positions. We've prioritized cybersecurity, even at the time we filed our budget. And as you can guess, those are a higher priority for us today than they were then. I would also tell you that our response to the cybersecurity incident and the necessity of fortifying and upgrading our systems has caused us to make unforeseen expenditures. We are thus been talking to the budget committees about a supplemental appropriation, and this would cover expenses to date or expenses that we can estimate with some certainty to date. We still have some expenses that are unknown and unquantifiable at this time. We are working to gather that information so we can provide those. Amy Deckard, our Chief Financial Officer, is here and present if there are particular questions about any part of our budget. And finally, I want to address your question about the cybersecurity incident. I discussed this during my State of the Judiciary, and I hope maybe that answered some of the questions you might have had. I will update you and say that as of today, our district court management system is again operational, and that the district court public access portal is restored. The last major program, as I mentioned last week, was our e-filing system. Progress since I spoke to you last week has been good. We were able to bring up our three largest counties, Sedgwick, Shawnee, and Wyandotte. Today, we restored 10 additional districts, and it looks like we will be good to go with most of the remaining districts tomorrow and the rest of the week. We still have some limitations on functionality, but we are working to close that. And actually now, once we have everybody on, I think those things will get ticked off fairly rapidly. So the last remaining project is bringing our appellate clerk system up with the case management and an e-filing system. And hopefully that is on the horizon. I know you may have questions about that incident. We have several people here to be able to help me answer questions you might have. I will note from the outset that there may be questions we can't answer. The forensic investigation is still ongoing. And additional, it's possible that there are some information that might be covered by KSA, by exceptions in KSA 45/2021. So we want to be sensitive to that as well. But bottom line, I thank you for your time and attention to this brief update of a few things, and would welcome any questions you have at this time, either for me or members of our Office of Judicial Administration.
Thank you so much. We really appreciate it. I think we're just going to start with some general questions, and then we may move into more specifics when we need to. But first, Representative Mon, you had a question? And this would be about remote proceedings or the budget, and then we'll maybe get into the cybersecurity in just a minute once we've answered the other questions.
Thank you, Madam Chair. I actually have several questions that are kind of broad, and if you'll give me some leeway to kind of follow up as we go. Chief Justice, thank you for being here. The first question I have is, do we know what is leading to the lack of attorneys? I'm hearing this everywhere about this sort of legal desert, I guess, and I'm trying to figure out whether we know what led to this. Is it just not enough attorneys graduating or being admitted, or just retirement is kind of weird? If you have any knowledge on that.
I hope I can give you better information about that in a few months. Our Rural Justice Initiative Committee has been doing surveys of attorneys and others trying to get better ideas. But some of the topics that are frequently mentioned are that nationally, applications to law school have decreased fairly dramatically. Many people believe this is the cost of the legal education and the time that it takes. We are lucky to be in a state where both of our law schools are responding to that and have developed programs. Some of them are called 3+3 programs, so that students can get both their undergraduate degree and their law degree in 6 years. The fourth year of undergraduate counts at schools at universities that participate in this program as the last year of a bachelor's degree and as the first year of the law degree. So that is one program that I think will help perhaps encourage. The other thing that I think overall cost is really maybe one of the biggest drivers, frankly. So we are looking at other programs and maybe talking to you about possible scholarship opportunities to help with some of that as well.
And that was the follow-up question: is what can we as a legislative body do to try to help this? Because it is apparently a problem. I hear it all the time now. And so as a legislative body, what can we do to help fix this?
Some of this, as you all will, some of you, especially in rural areas, know very well, is truly a problem of our state, and it isn't just the legal community. Rural areas have trouble attracting professionals of all types and just even increasing their population. So we reached out and felt like these are discussions that we shouldn't just have in the silo of the legal world. So our Rural Justice Initiative includes representatives from all sectors, including the rural economic experts. We have people such as from the foundation, some of the foundations that help support professionals in rural areas. We have reached out and had discussions with the medical school, the K-State Veterinary School, and others who face similar challenges and have collaboratively talked about solutions to the overall problem, because it is housing, childcare, broadband, and the list goes on and on and on. So addressing some of those governmental and community infrastructure issues is a big part of addressing the shortage as well, I believe. So
I guess this is more of a comment than a question, but it just seems to me that we need more judges, more prosecutors, more defense attorneys, and more civil lawyers, and that will require more bids pay and more money. Yes. So I appreciate.
Well, we, of course, are extremely thankful for the raises that have been given to our employees and our judges. The judges haven't kicked in yet, so we don't really know how that may impact recruitment. We were to a point where we had positions that were going unfilled because of lack of application. When we did the demographics of the state and look at counties and take out the judges from the attorney count, there's no bench in many counties. There is no one who currently resides in that county to take the judge position. And so unless somebody's willing to move into that county, we are going to be facing a serious issue that will be, before you, because of the statutes that are in place, to figure out what we do next if we don't some way find a way to reverse this trend.
The next question, if Madam Chair will allow, is what can we as a legislative body do to help pro se litigants? Is there something, because obviously that takes the pressure off this attorney shortage problem. If we can, is there anything that you think that we could?
I think if I can speak for my colleague, Mr. Keenan, I think increasing amounts of money that go to Kansas Legal Services and similar programs would go a long way in that. Also continuing to support the programs that we are building internally also help a great deal with that. And of course, on the criminal side, it's operating the criminal justice system, the criminal court system is a three-legged stool. I think you've probably heard prosecutors say that, and I am pretty confident Heather Cessna uses that reference in her testimony. If we're not fully and adequately funding each leg of that stool, and I know some of that's left to the counties, but two of those legs are yours, we have an imbalanced system that just doesn't function correctly. So fully funding the Board of Indigent Defense Services on the criminal side would help as well.
Thank you, Chief Justice.
I just wanted, excuse me, we are going to hear on the Senate side, we are going to hear a presentation later this week in Judiciary Committee on Thursday from the Board of Indigent Defense Services to get an update and also to hear what the state is doing in its obligation to provide counsel for indigent defendants in certain criminal cases to comply with statutory speedy trial and to get those cases moving along as well. So to be continued, this discussion. So thank you, Madam Chief.
Representative Schreiber, you have a question? Yeah.
Thank you, Madam Chair. Chief Justice, thank you. When I was listening to you talk about remote hearings, it kind of drew me back to when you talked about criminal mediation had expanded during the pandemic. Do you see that trend continuing?
Yeah, definitely, very definitely.
Okay.
We wish nobody had to live through the COVID pandemic. But it did help move the court system forward more rapidly than probably anything else has in history. It's caused us to think about how do we, our goal really is to help serve those Kansans. And we always thought of it in this very traditional way. And we were increasingly looking outside for innovation and new ways to do it. But COVID really forced us to do that quickly and embrace it. As many of you know, we set up the Protection from Abuse portal, and so that people can remotely apply for those protection orders more safely, more quickly. And that has been a very well-received service. Again, just another one of many examples I could give. But criminal mediation was something a few districts did, but now it's really something that many districts are using. And it really is, frankly, I would have told you today we have a significant criminal backlog left from COVID, but for the success and the that we had with criminal mediation and some of those other innovative programs like the one I spoke of in Sedgwick County. And so we appreciate the flexibility this body gives us to be able to do those things and to innovate and make those changes.
Madam Chief, if I could, I'm glad to hear that it's primarily non-evidentiary hearings that are being held remotely, because it's one thing to see an item of evidence, a physical piece of evidence on camera, and it's another to see it in person if you're a juror or a judge, the fact finder, if you will. So I'm glad to hear that not a lot of evidence is being put into the record except for uncontested evidentiary hearings. Is that kind of the right status?
Yes, I think
Okay.
generally. Now, there are exceptions, of course, and to accommodate those exceptions, districts have learned how to exchange and most of them have protocols, if you will. I hate to call them rules, but protocols about how that happens. And almost always, any evidence that's going to be presented has to be shared days before the hearing, so that everyone has an opportunity to have a physical copy of it. Those things are considered when we do have to, when a court does do an evidentiary hearing. And frankly, there are, again, are resources available that have been, and one thing we are looking at is a statewide system, so that an attorney doesn't have to learn one system in Johnson County and another in Wyandotte or wherever, so that when those occasions do occur, it will be a more unified system.
Thank you. That kind of leads into my last question regarding the cybersecurity incident. And we have 105 counties in Kansas. 104 were impacted by that cybersecurity incident. The one that wasn't is Johnson County. I know a lot of practitioners in that area, and Johnson County court system was not affected because it wasn't part of the integrated statewide system. So is the plan of the judiciary still to move forward with integrating everyone, and then we're all in it together, I guess? So what are your thoughts on that?
Yeah, yes, it is. The plan is to move forward with bringing Johnson County on in this calendar year. The thoughts are, one of the things that we learned very quickly after the cyber incident was that even though it had been a very, very short time that the public had access to statewide case information, it was extremely popular. So it's one thing to have 104 counties with that kind of public access, and than to have 104 and then, oh yeah, go over and make sure you look here as well. Statistics, just even for court management, as we try to track and help courts manage those time standards that I mentioned, we, with the statewide case management system, can do one system for 104 counties, and then we have, oh yes, there's another county. So there are real benefits to bringing, to unifying those functions. It also improves the financial controls, the receiving of monies, and all the various things that relate to that. So our goal is still to do that. Now, to respond, we did learn that our system there were improvements we could make that, heaven help us if we're ever hit again, we could hopefully restore and recover quicker than we did this time. Lessons learned, steps taken, and we feel like we would be in a better place. And we are told, and frankly, we think maybe there are backups for that can help. Wyandotte County, for example, the county was hit some time ago. We were the more of us that are in it, the more cooperatively we can help each other too. So,
And regarding some of the other districts and counties, are they going to all be subject then to the same local rules? There won't be local rules for each judicial district. They'll all be the same. And would that also mean some of our current counties, you have to be an attorney of record to be able to access what are supposed to be public records in the case? So is that all going to be consistent across the state? Is that what you're saying? Or will we still have local county and district rules?
in terms of access to records, that will be uniform. But there will still, I'm sure there will still be local rules. There will still be rules by division. Those of you, many of you probably are very familiar with that there are some judges who have rules specific to the way he or she will handle cases. I don't know that we'll ever be able to rid attorneys of that. But anyway, there will be more uniformity for certain.
Thank you for the answer.
I think we have another question, Representative Carmichael.
Madam Chief Justice, thank you, Madam Chair. That's okay. I can do this. It's a pleasure to see you again. I recall testimony only just a few short years ago. It seems like a lifetime in the midst of COVID when we were under very difficult circumstances. I appreciated you coming to see us then, and I appreciate you coming to see us today. I would like to return, however, to this matter of remote testimony. When I started practicing law back in 1982, we were able then to present the testimony of an unavailable witness in court in front of a jury by reading a deposition to them. The lawyer would read the question and someone playing witness would read the answer, and we would go back and forth, and then the cross-examination would be accomplished in the same fashion. And by the way, unavailability is somewhat broadly defined in our code of evidence and includes being more than a certain number of miles away from the place of trial. Now that I'm a retired lawyer, Madam Chief Justice, I don't remember whether that's 100 miles or 200 miles, but it's something like that. Then as we developed videotape machines, we started videotaping the depositions of witnesses who were hundreds of miles from the courthouse. And then we would come in and we would play the videotape in front of the jury. Once again, the witness being located hundreds or thousands of miles away. But what I don't think we can still yet do under our Code of Civil Procedure, our evidence code actually, is to remotely and live real time present the testimony of that witness to a jury in a jury trial. Seemingly, we can only do it by deposition, which is either a written reading of a deposition or playing of a videotape. I believe 7 or 8 years ago, I think it was the court under Chief Justice Nuss, and I believe it was Chief Judge Arnold Berger, who may have presented to us, suggested that perhaps we ought to entertain live remote testimony. If I'm remembering that correctly, has there been any change in the thoughts of the court, especially based upon the experience we now have with using Zoom for everything from workers' compensation hearings like I used to preside over to criminal arraignments, dockets, etc.? Could you address those issues, please?
No, I do not believe there has been a change of thought about that. I think that would be very broadly supported. If anything, I think that perhaps people are using the provisions that we have now to allow that type of a hybrid hearing and to bring in the $4,500 an hour expert, which obviously has their advantages to being able to do the live testimony instead of in the middle of a trial, as things have developed and issues have become clearer from the testimony of other people, and to have that person answer questions in real time, than it is to look back to a deposition they gave 6 months or a year ago. So justice is certainly served by allowing and accommodating that. Again, reduces the cost of litigation for individuals.
Well, Madam
Where it
Chief,
happens, it's usually with the consent of both parties and the judge.
right. Madam Chief Justice, I appreciate having a Chief Justice who has tried cases and been there in the trenches and understands what happens with a stale deposition taken 6 or 8 months ago, and then you present it and it doesn't match the testimony at trial. And I appreciate your recognition of how expensive it is to fly expert witnesses across the country to testify for an hour and a half and hop back on an airplane. Thank you, Madam Chair.
Most of them do not discount for travel. Yes, I remember, if I can tell a personal story, the excitement when I was a trial court judge and we got a big screen TV behind the witness box, so that when those depositions recordings were played, the jurors could actually see it, not just see this little screen where it previously had been. So.
I used to have to bring literally my own big screen TV and VCR, whatever those were, to the courthouse. Thank you, Madam Chair.
Thank you.
Yeah. So now, because of some issues with, I think there's questions about the cybersecurity, I'm going to call on Representative Mon for a motion.
Thank you, Madam Chair. I move that the open meeting of the House Committee on Judiciary be recessed for a closed executive meeting pursuant to KSA 75-4319A to discuss matters relating to the security measures with Chief Justice Marla Luckert, Special Counsel to the Chief Justice Marissa Bayless, Judicial Branch Chief Information Technology Officer Kelly O'Brien, Judicial Administrator Stephanie Smith, Deputy Chief Information Technology Officer Ann Madden Johnson, and Judicial Branch Chief Financial Officer Amy Deckard, pursuant to KSA 75-4319B12C, because the discussion of such matters in an open meeting would jeopardize the security measures. So I move that the committee resume the open meeting in room 346S of the State House at 4:45, and to record this motion if adopted at part of the committee's permanent records.
Do we have a second on that motion? Representative Lander, any discussion? Okay, for the House, all those in favor of the motion, say aye. Opposed, no? The motion carries. Senator Warren.
Okay. Thank you. Committee, this is not the usual Senate Judiciary Committee meeting time. We usually meet in the morning at 10:30, and due to the weather and the change in time, we do have our committee members, a lot of them, appearing on WebEx today. So WebEx is not the same as being in the committee meeting room. So we'll see you after executive session. Thank you.
We'll go into executive session now. Are we back on? Yes. Okay, so I do think we have a few more questions, but I think we can ask them publicly from what I understand from people who do have a few questions. Yes, please.
Hold on, hold on.
Okay, just a second. We don't have the video up quite yet. Okay. Hey, Mark, do you want to ask your question? Oh, okay. Mm-hmm. Was almost there. There we go. Okay, we're going to continue with a few questions and just let it be on the public record. Representative Curtis. Representative Schreiber had his question answered, so you're next.
Okay, thank you. Thank you, Madam Chair. Thank you, Chief Justice, for being here. I know that courts have been kind of a target across the United States, so we aren't the only ones. They have been targeting courts all over. So, and we all know that it's just a matter of time before somebody is vulnerable, somebody gets hacked, but we can put some things in place. And just to share with the committee, I serve on a lot of the technology committees on the Joint Committee for Information Technology, and some things that I think we did last year that maybe have been helpful. And so I'm asking you if this was helpful in when it happened to you. And that last year we established a mandatory reporting. So if anybody that is connected to our state system does have a significant incident, they have, I think it's 48 hours, if I'm correct, to report that to our cybersecurity team that then will bring in some resources and some help. I know you all did that reporting in a very timely manner. Was having that reporting process in place and then having that assistance available, was that something that you found to be helpful?
It was extremely helpful.
Okay.
We had no email. The office helped us do a workaround for at least to make sure we had I should say we had no secure email or email we felt comfortable saying was secure, and we were able to do that with them. They lent us laptops because we didn't even have laptops. They were able to deploy those. We borrowed from the executive branch, and I think maybe the legislative branch offered a few too. I'm not sure, but I know the executive branch offered us some laptops so that these people who needed those to start troubleshooting the system had a way to do that. And so, because we had some, but not enough. So all of those things were, and then they were there. We had representatives join. I can't even begin to tell you how many hours we've spent in meetings troubleshooting, and we have had members from that office who joined us on weekends from their kids' soccer games. I mean, I could give you lots of examples of how much sacrifice they gave to us and help they gave to us as they helped walk through and troubleshoot and think about what next steps and what to do and how to do it or how not to do it, those kinds of things. So they were extremely helpful. We're very, very appreciative of that.
And if I could follow up, I just think that that's good to know. So as much as we can put in that's preventive. And I know one thing that would be very helpful is for all of our government entities to move to a domain that is a true government domain that then provides that additional help and security. We're on .gov. .edu would be another one. And then you're on a government agency. And then also, in part, and I guess I'm speaking to my fellow committee members, is that we all need to be aware of cybersecurity and know when to click and when not to click. And training is so important. So thank you. I appreciate your answer. And it's good to know that legislation that we put in place was actually helpful.
And if I can protocol and add a little bit, I would say that we are very committed to paying it forward for this help that we got. We want to help other people in this complex. And we, you know, as much as you think you've planned, there are things that we hadn't thought about, you know, and we now have that lived experience. No two incidents are the same, but anything we can add to help other people, we're there to do that. Or we're here to do that, whatever.
Another question, Representative Smith? You have a question?
I do. So I also chair the Kansas Joint Committee on Security. The day after your incident, we had a closed door session with the Kansas Information Security Officer. No mention of what was going on. We had nothing. In fact, my first clue that this happened was on WIBW the day after. And that was because my county attorney told me I probably ought to watch that. My curiosity is about the reporting. If we weren't allowed to hear the legislature in a closed door session what was going on, who was? Apparently the news. So how was that reported? I'd like to know kind of a timeline of how that went.
I could give you specifics. Off the top of my head, I'm a little fuzzy about exact timelines. I don't know if anybody else feels that they're better prepared to do that. Kelly, do you?
If you would introduce yourself when you get to the microphone. Thank you.
Kelly O'Brien, I'm the CETL for the judicial branch. To your question, we on October 12th was the day, that morning we found out we had an issue. I believe the exact time that we reported that would have been about 12:30 that day to the security officers, a form and everything that you're supposed to fill out. We also, because we're a ks.gov member, I reached out to KBI and Highway Patrol as well. And told,
that day.
the 12th, and told them that we had an issue, and that at that point we didn't really know how bad it was, but we know we had to disconnect our systems, and that it was obvious we had an issue. So, and I think by that later that afternoon that the security office actually had people over in our building. So, and I know KBI, I think that was a Thursday. I think KBI was actually over on a Friday. So yeah, it was pretty quick to turn around. By the way, I think it's 12 hours, not 48 hours. I think I have 12 hours to report it. So at least that's what I thought. And so, yeah.
Well, I appreciate that. Part of the presentation that we had from the KSO involves cybersecurity threats and the current threat condition. I can't go into it in depth, but it's odd to me that we would have that presentation about 28 hours later after the event and no mention of it to the legislature. And I had a conversation with the Speaker of the House on that issue, and we decided to let it play out. And I didn't address it immediately, but I was curious who gave the directive that it not be disclosed to the Security Committee, if that was given at all.
I can't answer that. I don't know the answer to that question.
All right. Thank you very much.
We have other questions? Anybody? You have a question? Senator Warren.
Thank you. And thank you, Representative Smith, for those questions. It was a little bit frustrating as a practitioner to not as a legislator, but even as a practitioner, not to have information, and certainly as a legislator, which was why I think we were bringing the joint committees here together to have more of a dialogue with the judiciary after Madam Chief's presentation last week to the state, where we didn't have the opportunity to ask and have questions answered. So thank you for coming over today. I don't really have a question, but just an announcement before we adjourned, if that's kind of where we're headed. For the senators and for those following along tomorrow for Senate Judiciary Committee or our conferees, want to announce that the Senate will be on the Senate floor at 10:30 tomorrow, which is our usual Senate Judiciary Committee meeting time. So we will be starting our committee meeting immediately after we adjourn from the floor of the Senate tomorrow, which I'm told is about 15 minutes. We will see. There will be a vote on an agree to disagree in the morning that we're having to do because we weren't able to meet today in the Senate per usual because of the weather and trouble of senators getting to the Capitol, where safety is our primary concern, of course. I wanted to make sure people weren't expecting us to start at 10:30 in Senate Judiciary Committee tomorrow.
Okay, otherwise, in House Judiciary Committee, we have a bill hearing tomorrow at our regular time and place. So thank you, everyone, for being here. We especially thank you for coming across the street and being here at our disposal. And thank you for answering all the questions. And we're adjourned.